Good evening. Welcome to tonight's panel presentation, Louis Brandeis and the Development of the Right to Privacy. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. For those of you who are not familiar with ACS, it's a national network of lawyers, academics, policymakers, law students, and judges that promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. We are very glad you could join us for tonight's discussion. The inspiration for tonight's event was Professor Mel Urofsky's new biography of Justice Louis Brandeis, Louis D. Brandeis, A Life. This rich and detailed biography explores every aspect of Justice Brandeis's life and the profound impact he had on the country and the law. As a scholar, a lawyer, and a jurist, Justice Brandeis's work transformed our thinking about free speech, the right to privacy, federal regulation of economic affairs, pro bono legal work, and advocacy before the courts, just to name a few areas where he had a profound impact. For tonight's event, fully recognizing the magnitude of Justice Brandeis's influence in so many different areas of the law, we decided to focus the discussion on one area where he has been credited by former Harvard Law School Dean Roscoe Pound with nothing less than adding a chapter to our law, the development of the right to privacy. We are delighted to have the author and two outstanding legal scholars on our panel this evening to trace the development of this area of the law from its origins to the present, where we see the right to privacy implicated in important ways through the First Amendment, the Fourth Amendment, tort law, laws affecting our intimate decisions, and state constitutional law. Before I introduce our moderator, I did want to draw your attention to the fact that Politics and Prose is here, and you may have seen them on your way in, selling copies of Professor Urofsky's book. And if you are interested in buying a copy, obviously you should stop back at the table. And I'm sure Professor Urofsky would be more than happy to sign your copy of the book. And we, of course, have refreshments, so I hope everybody will indulge, not too much if you're driving. But please help yourself. Now, I think you all have full bios of our participants today. So I will just introduce our moderator, Professor Bill Marshall. Bill is currently a visiting professor of law at George Washington University's Law School, where he's spending the year on leave from his position as the William Rand Kennan Jr. Distinguished Professor of Law at the UNC Chapel Hill Law School. He is a former Deputy White House Counsel and Deputy Assistant to President Bill Clinton, and a nationally recognized constitutional law and First Amendment scholar. Beyond his stellar credentials, Bill is also a critical part of ACS, serving as a member of our board of directors and has been intimately involved with ACS since its inception. We are very, very pleased that he could be here tonight to moderate tonight's panel, and so I will now turn it over to him. Bill?
Thanks, Caroline. And thanks so much for coming out tonight. We're really celebrating two things tonight. We're celebrating a superb book, which I'll talk about in a minute, and then we're also celebrating this notion of the idea of privacy. First, the book. This is a really wonderful book. It is not just about the law. In fact, that only colors its overall perspective on the times that Louis Brandeis lived. I learned a heck of a lot about Louisville and the economy of Louisville, and seeing the way the nation changed during Louis Brandeis's lifetime. So it's a book about the times. It's a book about a person of great eminence and a person who every single law school professor describes to be, because he wrote the only law review article that ever made a difference in the history of the United States, the 1890 law review article that he wrote with Sam Warren on the right to privacy. So he set forth a standard that we all aspire to. And this book really does a wonderful job in talking about not only Justice Brandeis's ideas, but his life, the intricacies of the politics of the moment, the intricacies of business and labor law, and all that, and I heartily recommend it. That is our segue into the idea that we're going to talk about tonight, which is this notion of the right of privacy. Picture about 120 years ago now, The world is changing dramatically in transportation, in the press, and the nature of the press and what the press covers. Telegraphs are giving notion to this idea of news, which didn't exist before, and immediacy. And photographs are capturing images in a way that we've never seen and popularizing all of this. And all of this is changing the way that individuals view themselves and view the society around them. And I really think it's been about 100 years that took place after that until we saw a similar kind of change that's going on now. Because the technological changes that are going on in our time are comparable to the technological changes that took place at the end of the 19th century in redrawing the way that we look at our lives and redrawing the way that we look at our boundaries. A little conversation that may have taken place between Brandeis and Warren in 1890 would have disappeared into the Ethernet, into the ethereal world. Right now, you send an email. If an email substituted for that conversation, it's around forever. And the implications of the etching in permanence of casual conversation, whether it be by text, whether it be by email, haven't really been grasped by the law yet. The ability of the government to monitor us by technological devices, some of which we're aware of, and if you read Jack Goldsmith's book, I think there are a lot of them that we're not aware of, monitoring what we do, create a new sort of threat on our privacy and our ability to distance ourselves from the government. And the way that we cover ourselves and the way that we present ourselves, whether it be by social networking devices such as Facebook or less popular and certainly more demonized kinds of websites such as AutoAdmit that took place in Yale, in which people's lives are completely exposed and damaged in this new virtual world of cyberspace, have changed the notion of what privacy means and what kind of protections and what kind of rules we need to protect our innermost selves in this very sense of what privacy is all about. And that's what we're going to talk about tonight. We're not just going to look backward and talk about Justice Brandeis' opinion in Olmstead, although we're going to talk about that, or his law review article. We're going to take a look at the relevance of the ideas that Brandeis set forth and how they might apply in our current world, where our technology once again is so dramatically changing and changing the shape of what human identity actually means. Couldn't have a better panel. I have to say we did lose one of our panelists today. Unfortunately, Anita Allen couldn't come down here from the University of Pennsylvania because of family health issues. She would have been a great addition to this panel. She's one of the leading experts on privacy and privacy in the United States, and we will miss her, but we wish her the best, and we wish her family the best with the health issues that they're facing in Philadelphia. But we can more than make up with that with the two distinguished panelists that we have on the dais with us today. The first is the author of this wonderful book, Mel Urofsky. Mel is a professor emeritus of history at Virginia Commonwealth University. He's a professor of law and public policy and professor emeritus of history at Virginia Commonwealth University. And before joining VCU as chair of the history department in 1974, he taught at the Ohio State University and the State University of New York at Albany. From 1995 through 2003, Professor Urofsky served as the director of the doctoral program in public policy and administration. And I can keep reading this forever, and I'm going to cut to the chase. He's written 52 books, which means, as far as I can tell, that by the time this panel is over, he will have authored a chapter. And I think the test for us to look at is see how he's writing it at the same time that he is speaking on this panel. But Mel, it's a true honor to sit on a panel with you and all the work that you've done. Ken Gormley is equally distinguished. Ken is the interim dean and professor at Duquesne University School of Law in Pittsburgh, where he specializes in constitutional law. He joined the faculty there in 1994 after teaching at the University of Pittsburgh School of Law and engaging in private practice. He has just completed a second major work of nonfiction called The Death of American Virtue, Clinton versus Starr, that will be published by Crown Random House in February of 2010, and I haven't asked him yet, but I want an advance copy of that one. It sounds like it's going to be a great work. Ken has appeared in major media shows throughout the country, and I'm sure you all recognize him, and you can all read his bio and fill out the blanks where I've just left it. But I'd like to turn this over to Mel right away to begin our discussion.
Thank you. Anybody who goes to law school, of course, reads Olmstead, which is the great 1920s case dealing with wiretapping and prohibition. And when we think of Brandeis and the right to privacy, that's usually where we start. But when I was, we all knew that he had written this law review article back in 1890, but none of us had really read it. Or let's put it this way, only a few of us had read it. Bob Post read it, and I read his article on it, and I said, I've got to read this because I don't recognize this. And I went back, and I read it in the 1890 Harvard Law Review, and one would not guess that there's any connection between this article and the Olmstead dissent, other than privacy is mentioned in both. Part of it is Olmstead is a constitutional case. And what Brandeis and Warren had to do in the 1890s was to work with the materials they had then. You have to remember that this was before incorporation. The Bill of Rights did not apply to the states. Moreover, that there had been relatively little jurisprudence on the Bill of Rights, even with the federal government. We were just beginning to get a few cases on what the Fourth Amendment meant. There was practically nothing on the First Amendment. And the article arose because Sam Warren was a scion of Brahmin society. He had married the daughter of a U.S. senator, and they'd become the social leaders of a younger set in Boston, and reporters were always trying to get into their house to report on their parties. And Sam didn't like that, so he asked Brandeis to work with him on this article. And the only thing they had to work with was tort law at that time, essentially the unauthorized use of one's likeness. There wasn't much else. And from that, they teased out what actually became several new torts, but they also, in that article, did talk about the right to be let alone and the threat that technology presented to that right. At that time, the technology was photography, and Brandeis warned that what is whispered in the closet shall be made known upon the rooftops. It was an extremely important article. Until after World War II, it was the most cited law review article in American history. And Brandeis continued his interest in it. Every time there was a case that involved the right to privacy in any way, shape, or form, and at that time was mostly tort cases about people, using somebody else's photograph to endorse a product or something like that, he took a great deal of satisfaction in it. But he never followed up on that. Sam Warren wanted him to draft legislation, wanted to do other things, but Brandeis got sidetracked. He met the woman he would marry. And as we all know, when that happens, we don't write chapters even while we're giving, talks. He goes on the Supreme Court in 1916. And in the 1920s, prohibition generates enormous changes in American law, much as the railroad had done 100 years earlier. And the case that we're most interested in, there was a man named Roy Olmstead, a former policeman in Seattle, Washington, who set up a prohibition ring that could have been and probably should have been a case study at the Harvard Business School. It was extremely well done. At one time, they were running 2 ships that could go back and forth to British Columbia to get the booze, plus an armada of smaller ships that ran up and down the coast. They bought a ranch with underground storage facilities. At one point, they had as many as 70 people working for them, and were taking in terms of current dollars, roughly $25 million a year. And in their main office, they had a bank of telephones. The number was given out to customers who would call in and say, I want a case of scotch, I want this. The office was manned from early in the morning till late at night, so if you're having a party and discovered you were running short on scotch, you could call this and Olmstead's people would deliver you a case or two. Right? Federal agents put a wiretap on the phones into Olmstead's office. They went down into the basement, and what today would strike us as very crude technology, they took a headphone and 2 alligator clips, and they hooked on to the leads. They also wiretapped Olmstead's home, as well as the homes of some of his associates. And over the next 6 months, they got several hundred pages of transcripts indicating the extent of this, who on the police force was being paid off, all the stuff that goes with a successful criminal enterprise. Olmstead, after being convicted, and there was no warrant on the wiretaps, but the wiretaps led the federal agents to be able to get a warrant to go into the office, seize papers, etc. And on his appeal, Olmstead's lawyers claim that without a wiretap, the evidence secured by, without a warrant, the evidence secured by the wiretap could not be introduced at his trial. Chief Justice Taft, for a 5-4 majority, writes what is most kindly described as a wooden opinion. There was no insertion into the house. No one went onto the actual premises. Therefore, there was no Fourth Amendment violation. All they did was listen in from outside. 4 people write dissents. Pierce Butler, normally considered one of the 4 horsemen, a conservative, shreds Taft's logic. Holmes writes a fairly short dissent because, as he says, Brother Brandeis has said everything there is to say, but I call wiretapping a dirty business, a phrase that immediately caught everybody's attention. Harlan Fiske Stone said, I agree with Brandeis, Holmes, and with Butler, and I do think that once this case was introduced, essentially Brandeis had the right to go afield because Taft was very upset in his opinion, said that the dissenters went into areas that should not have even been covered. It's the Brandeis opinion, of course, that caught everybody's attention. And in it, he did several things. One of which was he enunciated for the first time a constitutional right to privacy, which he called the right most cherished by civilized man, the right to be let alone. And he went back and showed how the framers of the Fourth Amendment were concerned not just with physical intrusion into one's premises, but with what we would now call a zone of privacy, an expectation of privacy in certain areas. And that it didn't really matter whether the wiretap operators were inside or outside the premises, they were intruding into this expected area of privacy. He also writes a couple of sentences that I think ought to be on the office of every chief executive of the United States, and I said this repeatedly between 2001 and 2009, that the government is the chief teacher, and if it is a lawbreaker, it teaches the rest of us to break laws. It took Congress a few years. Taft had said that if Congress wants to outlaw this evidence, they can. They did that in the 1930s. And then, of course, in the 1960s, we get cases like Griswold, which do enunciate a right to privacy. And we get several wiretap cases, which hold that you do need a warrant for wiretapping. And Potter Stewart says that the Fourth Amendment protects not places but persons, the idea that each of us carries a sort of zone of privacy with us. I want to finish by referring to a case that was handed down just a few terms ago involving Danny Lee Kelo. Police had gotten the tip that Kelo was growing marijuana, but they didn't have enough evidence to get a warrant to actually go into Kelo's house. So they got a heat sensor. And they drove up and down the street, and as all of you who have watched Saving Grace and other movies know, it takes a lot of light, which generates a lot of heat, to grow marijuana. And so here's the heat sensor, and they get to Kelo's house, and it goes like this, and then when they get past, it comes down again. On that basis, they get a warrant, they go in, and sure enough, Danny Lee is growing a lot of plants. And they arrest him. And he raises the same defense that Roy Olmstead did 70 years earlier. You intruded into my private space. You did it without a warrant. That evidence can't be admitted. He's convicted at the lower court. The Circuit Court of Appeals affirms it. The Supreme Court reverses it. And the author of what I can only term a very Brandeisian opinion was Antonin Scalia, the last person one might have expected to do that. And what he essentially writes is, using that sensor violated Kelo's private space. And you can't do that. You can't do it technologically. You can't do it physically without a warrant. And I think to some extent, Kelo is not necessarily a predictor, but a sign of some of the problems we're going to have. A few appointments back, my friend Jeff Rosen wrote a piece in the New York Times, which he said we should stop asking judicial nominees what they think about abortion because that's really over. They said even if Roe was overturned, it's not going to make too much difference. What we should be asking them is, what do you know about computers? What do you know about technology? How facile are you with technological innovation? And these were the sort of questions, he said, that are going to be on the agenda of the Supreme Court, at least for the next generation. How we deal with the technological revolution. What was it? Yesterday, the court heard a patent case, I think, on whether or not you can patent an idea. The idea being one way to sell securitized, all the stuff you want to buy for your portfolio. And just as we had to deal in the 19th century with trains and the havoc they wreaked as they went across the country, in the 20th century we dealt with a new technology. In this 21st century we're going to deal with another one. I should add, by the way, that when Brandeis wrote his Olmstead opinion, he had a clipping in his file about a new innovation called television. And he wanted to include a warning against television in the opinion, but his clerk, Fred Friendly, talked him out of it, saying he was worried the old man was going too far. And, of course, Brandeis was absolutely right on that. And I'll stop there.
Unlike Professor Urofsky, I'm not retired, so I don't feel comfortable sitting in that chair. In fact, I have an 8 o'clock class tomorrow in con law in Pittsburgh, so I have to stay in shape. But I do thank you for the opportunity to be here tonight. My own connection with the discussion, I guess, is a couple different angles. The first book I wrote, Bill mentioned the second one, but the first one was the biography of Archibald Cox, one of the great constitutional lawyers of the 20th century, my law professor at Harvard, a man who I know from my own discussions revered Louis Brandeis. And I'm also here to publicly recognize Professor Urofsky's new book, because I just finished the second nonfiction book of my own. And after 9 years of working on that book, I know what kind of somewhat irrational commitment it requires to actually finish a book of this scope. So I'm here to salute Professor Urofsky for actually going into the salt mines and completing the work, not just completing it, but producing a work that exceeds the highest standards of excellence that any author could hope to achieve. So I'm honored to be on the platform with him today. And finally, I am here because I teach constitutional law. And one of the earliest pieces I wrote as a law professor in the early 90s had to do with celebrating the 100th anniversary of this article by Warren and Brandeis. And so I've spent a good bit of my own academic career paying attention to Brandeis's right of privacy, and I do believe that without it, America would look quite different than it looks today. One of the principal things that struck me when I went into my own salt mines back then for 3 years to work on this privacy article was how history and specifically advances in technology had advanced privacy in very concrete ways at each stage, kind of propelling forward Brandeis's notion of privacy, allowing it to branch out into different directions. And I think that's one of the great things that this book shows, is how Brandeis consciously sought to kind of harness some of the changes taking place in American society and to deal with these things head on. So each type of privacy that we recognize today as part of this right to be let alone, whether it's part of our common law, our statutory law, or our constitutional jurisprudence, can be traced, I think, to rather dramatic societal changes. So let me give you a brief snapshot of these. As we heard, it was in the winter of 1890, 1891 that this article was written by Brandeis and his law partner, Sam Warren. It was just 27 pages long. The other enviable thing for any law professor, very few footnotes. It appeared in a law journal that was brand new at the time. This was only the 4th issue, so had no real track record. Brandeis and Warren couldn't have possibly known what kind of impact, if any, it would have. And the initial type of privacy, as was already mentioned, that they introduced to American law was a tort notion of privacy to deal with this, the right to be let alone from prying newspapers and photographers and others who were intruding upon individual space, no different than an assault that was occasioned by a trespasser or by someone committing assault or battery. So the truth is that this initial notion of the right of privacy that Warren and Brandeis said was so well entrenched in American law really wasn't entrenched at all. In fact, there were little bits and pieces of it that you could dig around for. You could go back to William Penn and show that he wrote a poem in the 1600s called On Some Fruits of Solitude, and one verse was called Privacy. So there were some things that you could point to, but nothing even remotely resembling in America the kind of privacy that we today have become accustomed to. And this was one of the things that kind of stopped me in my tracks when I was researching. You go back and look at colonial America. Lodgers would be traveling across the countryside in their travels and would stop at homes, share rooms, share beds with other people they didn't even know. Family members would get dressed and undressed in the same room together because there was no electricity, very small quarters. Small towns were set up on linear grids and often in a way that all citizens knew exactly what everyone else was doing. And in fact, as you know, there were in some cases town tattlers. So there was a smattering of case law to suggest and precedent that there was some notion of this concept of privacy in the law. There were these cases involving a notable case where a woman's likeness was all of a sudden she goes by and sees it on a Christmas card in a store. Or the famous New York case where a woman wearing tights in a Broadway play was secretly photographed by two theater goers who used a flashlight and then were going to publish it in a newspaper. The fact of the matter is, though, that there was no right of privacy in the United States until Warren and Brandeis introduced it in this article. And as Professor Urofsky makes clear in his book, all of this was spurred forward by new technology at that moment in our country's development. This was the heyday of yellow journalism. The industrialization of the United States had people swarming into cities, and so this introduced mass circulation newspapers. So the old one-penny press were dusted off, and all of a sudden publishers were selling their papers in the streets. The more sensational the topic, the better. You had better types of printing, color printing, cartoons. Photography was now somewhat perfective. As one writer later described it, it was a palliative of sin, sex, and violence. And there were legendary abuses at this time. It was called a period of keyhole journalism. So there was a real sense that people were being bombarded in all directions with invasions of privacy in a way never before imagined. And so it was that shift in technology that allowed this notion of privacy introduced by Warren and Brandeis to stick, first by statute in a number of states, California in 1899, Virginia nearby here in 1904, then in the first restatement of torts in 1939. So it was an action in tort, no different than a punch in the nose or whatever. Now we move to, as Professor Urofsky just described, by 1916, Brandeis has been appointed to the Supreme Court by President Wilson. And he was incidentally, and it's nicely described in Chapter 18 of the book, there was a fierce battle to prevent him from being appointed to the court. He was viewed as, among other things, too progressive and maybe radical. And one of the radical ideas that we now know he carried with him to the Supreme Court was this still developing notion of privacy. So then when we get to the Olmstead case, Professor Urofsky just described in 1928, we see the introduction of privacy in a constitutional sense. And again, it's based on new technology, now wiretapping. And Brandeis really did push this notion hard. He lost in that case, but he was vindicated ultimately in 1967 in the Supreme Court case of Katz versus United States. That did say, of course, that there was a notion of privacy subsumed by the Fourth Amendment that was broad enough to encompass wiretapping and electronic surveillance. Now, again, stop and think about it, and many of you were around during this time. This period of time in the late 60s and 70s is a time when technology is exploding with respect to snooping, spying, bugging. You remember Man from U.N.C.L.E., Get Smart, where the TV shows, there was a real sense that this was a crisis. And in fact, President Lyndon Johnson, in his State of the Union in 1967, said, we should protect what Justice Brandeis called the right most valued by civilized men, the right of privacy. We should outlaw all wiretapping, public and private, wherever and whenever it occurs, except when the security of the nation is at stake. So now we have a second type, what I call a search and seizure privacy. Home is your castle privacy. It's a constitutional privacy now in American history. And he was also involved in a third type I don't want to spend much time on, but it was this First Amendment and privacy. It is somewhat rare even today, but he introduced it in a case called Gilbert versus Minnesota in 1920, involving a Minnesota statute enacted during World War I, which made it a crime to discourage enlistment of men in the military. And Brandeis dissented and condemned this as saying, well, you could have parents just espousing pacifism in their own homes. And he said this invades the privacy and freedom of the home, some notion of a First Amendment privacy in the home. And then he turned it on his head in a case called Packer Corporation versus Utah in 1932 and said that this right to be let alone was actually powerful enough to defeat the First Amendment rights of others. Where there was a captive audience, in this case, advertisements advertising cigarettes and other tobacco products on billboards and streetcar signs, etc. And that notion of this privacy that can defeat First Amendment rights reappears and is embraced by the full court in the Breard case, Breard versus City of Alexandria, involving door-to-door salesmen. So we have a third type, and you see the right of privacy is now occupying some preferred status in American jurisprudence. It's strong enough to outweigh the First Amendment in certain cases. And most importantly, perhaps, in terms of understanding the progression, is a fourth type of privacy that I call fundamental decision privacy that came to life in the 60s and 70s with Griswold v. Connecticut, Roe v. Wade. By this time, of course, Justice Brandeis was off the court, was deceased. But this finished product certainly bore his mark because here the court borrowed heavily from those other two types of privacy to say there were certain fundamental personal decisions, whether to use contraceptives for a woman to decide whether to have an abortion, that were protected by the word liberty in the Due Process Clause of the 14th Amendment. And I could go on and on about how there were, again, historical triggers. Here it was the evolution of technology in medicine that had perfected the birth control pill, that had made abortion safer than childbirth, at least in the first trimester by the time you're in modern hospitals in the late 60s and 70s. So again, the same pattern. And here's a little known fact, incidentally, that Justice Douglas's famous reference to penumbras, you all know that if you've taken con law, in the Griswold case, can be traced directly to the largely forgotten dissent of Justice Oliver Wendell Holmes in Olmstead. And Holmes is borrowing from Brandeis there, where he suggests that there is a right of privacy in these penumbras surrounding the Fourth and Fifth Amendments. And also Justice Goldberg, who concurred in Griswold and said that there was a right of privacy emanating from the Ninth Amendment, directly attributed Brandeis's dissent in Olmstead and said that he had comprehensively summarized the principles underlying the guarantee of privacy. So 4 different types of privacy in American law. And there's a fifth. I don't want to spend much time on it, but I teach state constitutional law also. And let me just say that this is a fascinating area because, as many of you know, beginning in the 1970s, many states began dusting off their own state constitutions to expand rights for their own citizens, largely because of the rolling back of rights during the Berger and later Rehnquist courts under the theory of states' rights, returning power to the states. And one of the fascinating things is you had a number of states directly amending their constitutions to incorporate rights of privacy or interpreting them to include implicit rights of privacy. And so you can find whole pockets of jurisprudence dealing with search and seizure, dealing with fundamental decision rights, dealing with even tort-related rights that are buried into state constitutions. And the most fascinating thing for me, and something that Brandeis would really appreciate, you remember his famous dissent in the New Hope Ice case v. Liebman, where he talked about states as laboratories. Some of the greatest cases in state constitutional law are where the states use their own constitution to pave the way for development in the whole country dealing with the right of privacy. For instance, In the case, we're familiar with the Cruzan case dealing with the right to die with dignity in 1990, or at least the beginning of a sense that there might be a constitutional right broad enough to encompass that. Well, that really, that ball got rolling much, much earlier in the case dealing with Karen Ann Quinlan in the state of New Jersey. And that case was strictly decided under Article 1, Section 1 of the New Jersey Constitution that found a right of privacy in that Constitution. So not only do we have these different vines creeping out of the original right to privacy, but it jumps into the states and they begin developing novel types of privacy. In giving some fresh thought to this topic, after reading Professor Urofsky's masterful book, I thought I'd end by just commenting on what Justice Brandeis would say if he were plopped down in the United States Supreme Court today, more than a half century after his death in the fall of 1941. And I feel sure in saying this much, as Bill suggested in the beginning, he would certainly see, I believe, an acute need to evaluate new threats of privacy today and to adapt the law accordingly. Changes in society, changes in technology at every stage has been what has spurred forward the evolution of these different types of privacy. And I agree, it's really hard to identify any time in history where there's as much bursting out of the seams in terms of development of technology as this one. And so whether Brandeis would see fit to invent a whole new type of privacy to deal with these changes, I don't know, or just simply adapt the right to be let alone. But certainly the brilliant lawyer and jurist who comes to life in this book here would advocate in favor of retooling the current case law relating to privacy. And let me just give you a couple of examples before closing. In 2006, I had the privilege of testifying in the United States Senate on an issue that seemingly just fell out of the sky and directly threatened citizens' privacy rights in a fashion never before anticipated. The White House had just publicly acknowledged, after the story was leaked to the New York Times, that in the wake of the September 11th attacks, President Bush had authorized the National Security Agency to institute this program to monitor and intercept communications between persons on American soil, including American citizens and others abroad, presumably designed to pierce the al-Qaeda terror network. And according to the Justice Department's own white paper, these domestic wiretaps were carried out by NSA without warrants ordinarily required by the Fourth Amendment, and the Bush administration policy also circumvented the 1978 Foreign Intelligence Surveillance Act, many of you know as FISA, by which Congress had actually set up a special court to deal with precisely these types of issues, emergency requests from the executive branch. I never questioned the good faith of our president or our attorney general at that time. These were unusual times in this nation's history, and frankly, they still are. There was no doubt that the president, as commander-in-chief, even on American soil, was potentially had heightened powers to deal with the attacks at the World Trade Center, here at the Pentagon, and the continued threats of attacks by a new brand of enemy. At the same time, the defense offered by the Bush administration for this wiretap program was eerily similar to the defense offered by Harry S. Truman when he tried to seize the steel mills in 1952. And in fact, I told the Senate committee that in my view, I believe that President Bush's power, presidential power, was at an even lower ebb than that occupied by President Truman in the steel seizure situation because of one key factor, privacy. The Bush wiretap program, besides doing an end run around an act of Congress, also collided directly with the rights of citizens under the Bill of Rights, specifically the Fourth Amendment, i.e. this Brandeis Fourth Amendment search and seizure privacy. Only a court, and ultimately only the Supreme Court, can make a determination whether a seizure of telephone calls or emails or what have you constitutes a reasonable search or seizure under the Fourth Amendment. And these NSA wiretaps were being carried out in absolute secrecy, cutting out Congress, cutting out the courts. So ultimately, as you probably know, the Protect America Act did give the executive branch much of what it wanted, but it did it by amending the FISA statute, by doing it properly, and by including the courts in the process so that ultimately these privacy rights can be safeguarded. So Justice Brandeis, the author of that Olmstead dissent, certainly would have been extremely concerned with all of these new developments, with data mining, with satellite surveillance, with new technology that can sweep up all of our emails and telephone conversations, millions at a time, and the government using these tools to carry out its work. We are living in a world, ladies and gentlemen, where lots of these things do require fresh thought. We have the Google Maps and Street View, where you can have photos of yourself getting out of a car, maybe somewhere you don't want people to know you are. There are instances of women laying in their backyards in bikinis and men entering strip clubs and people picking their noses. I mean, everything all of a sudden is on these streaming videos. Cell phones allowed grade school and high school students to transmit photos of classmates undressed or engaging in questionable activities in their own homes, instantly posting them on Facebook, and meanwhile they're Twittering at the same time so that millions of people know what's going on. Louis Brandeis, whether intentionally or not, and I think it was more intentionally, gave us a vital piece of our jurisprudence that makes us uniquely American. What he recognized over 100 years ago, and what Professor Urofsky puts his finger on so beautifully in the book, and I encourage you to read the last few pages, are just eloquent in explaining how Brandeis was the man for this time, that there is no turning back on the right of privacy if we truly believe in the vitality of our democratic republic. The right of privacy has to evolve in unexpected directions as our society itself evolves, or we have big problems. And so I think that if Louis Brandeis were here at this symposium this evening, first of all, I think he would have to acknowledge that for all of his other accomplishments, looking back in hindsight, and frankly, I think he'd be fairly surprised by this, the right of privacy has to be considered one of his most significant legacies. Without it, I think we would have precisely the sort of legal system that our predecessors had set out to make sure we did not have in this country. And Brandeis would undoubtedly also take this opportunity to say a word of thanks to Professor Urofsky. Louis Brandeis really didn't ever set out, I don't think, to be immortalized in history books, but he was keenly aware of the power of history, and he liked to say, as we learn in the last line of this book, "My faith in time is great." And he would certainly appreciate the fact that Professor Urofsky's very patient work over many years now ensures that he is firmly anchored in the pantheon of heroes who built and who continue to safeguard our uniquely American system of laws. And so for that, I think we can all be thankful both to Louis Brandeis and to Professor Melvin Urofsky. And so thank you so much for the privilege of joining you here this evening.
We now can open up for a conversation. I want to pick up actually where Ken left off and where Justice Brandeis began with his famous right to privacy article, when he says, and this is set forth in Mel's book on page 98, "The individual shall have full protection in person and in property is a principle as old as common law, but it has been found necessary from time to time to define anew the exact nature and extent of such protection. Political, social, and economic changes," he didn't put the word technological in there, but he should have, "entail the recognition of new rights, and the common law in its eternal youth grows to meet the demands of society."
Right. That's a nice lead into one of the things that I think is key to Brandeis' philosophy, and certainly involves privacy and other things. All of you, I think, are familiar with the debate that has been going on for the last 2 decades between originalists versus interpretivists, and the notion that the true meaning of the Constitution was set once and for all in either 1787 or 1868, and that all we have to do is go back and read the minutes of the Constitutional Convention or the minutes of the ratifying convention, and that whatever has happened since really doesn't matter. That's the true meaning of the Constitution. Brandeis, in one of his opinions, dissenting opinions, writes, I believe in a living constitution, one that changes and adjusts to the needs of our time. And of course, before he went on the court, in some of his famous talks, he had said, the rest of society understands the changes that are going on, but the courts are blind to them. Now, one of the things that I think made Brandeis so powerful a reformer as well as a jurist is that he grounds almost everything he does not so much in new thoughts, but in old thoughts. Or I should say older values. What he's trying to do throughout the time that he's a reformer, throughout the time that he's on the court, is to take older values and apply them to contemporary times. His dissent in Olmstead refers very heavily to what the framers did, the values they had, and then how do we interpret this in our time. One of my favorite comments from William O. Douglas is he once said, what did the framers know about wiretapping? They didn't even have telephones. And his point is one that Brandeis would have recognized. There were no telephones. So you can't go and look at the Fourth Amendment to find out what it really says about wiretapping and then say, based on original intent. But what Brandeis saw as original intent was, what were they trying to do? And in the Fourth Amendment, he believed they were trying to protect the privacy of one's home, not just against physical intrusion, but intrusion into what I call this zone of privacy. He does this in the article. It's quite clear he does not have a lot to work with. But that phrase that you just quoted, he makes it sound as if all of history is really justifying the position he's taking, when in fact there's very little in history to justify it. But what he's trying to do there and in Olmstead and in Whitney and in other cases is to build upon what were the values of the Republic, what are the values of a democracy, what are the values that we as individuals hold dear and have always done so. And he believed in absolutes. There's a story with which I open this book that Professor Manley Hudson of the Harvard Law School came down to Washington, and all Harvard law professors had a standing invitation to stop by and see Brandeis, and he would, ask them what they were doing and how things were at the law school. And Hudson, at this time, had contacted Dean Acheson, who was Brandeis's law clerk then, and said he'd like to stop by. And Hudson was working for the League of Nations. He was promoting it and everything, and Brandeis said, and what are you doing? I mean, you're dealing in international law. And Hudson went on about how, well, international law is relative. It depends on who the countries are that are involved, what the situations are. And then Acheson reports this fantastic thing. Brandeis rose out of his chair, he was a tall man, and started thundering like an Old Testament prophet. Law is eternal. Truth is eternal. Principles don't waver because one country or another one. And Manley Hudson fled the apartment, absolutely terrified at what he had just witnessed. But that was part of Brandeis' strength, I think. He based what he was trying to do, his great ability to modify the law to meet modern times, was not taking the law and, let's say, forget everything that came before, but rather what was important in what we had before, and we build upon that.
I want to open this for questions in a minute, but I'd like to just start off with a specific question. Let's channel Justice Brandeis, because frankly I don't trust Justice Scalia to channel Justice Brandeis, even if he did do it in a Kylo opinion. And just ask the simple question that comes up, and this is part of the changing technology. We now, Google tells us, keeps a permanent record of every place we go on the internet, which is a scary thought, every search term that we use. When we use our little credit cards to get the discounts at Safeway, permanent records created. The government now has the ability to access complete profiles, data compilations of who we are and everything we do. So I want to ask both of you to channel Justice Brandeis, and first of all, ask you, how do we decide if data compilations of that type invoke this right of privacy? What would Justice Brandeis have asked us to look at, and how do we begin to use these concepts of privacy that he talked about and apply it to the new technologies and the new kinds of invasions of personal space that we see
Part of the
now?
answer is, what do we want known? I remember when Robert Bork's nomination was there and somebody discovered that there was a record of the videos that he rented. People were absolutely appalled. And part of the thing is, what do we want known about ourselves? In a society in which we have to use credit cards, in which you can't go any place without showing an ID, I had to, where was I? Oh, I was over at the Wilson Center earlier, and I had to show a picture ID just to walk in the door. If you travel, you have a passport that they run through a computer scan when you leave the country, when you enter the country. Part of the price of living in our society is we know we leave these sort of cookies all over the place. And I think the question Brandeis would ask is, how much do we want known about ourselves, and what right does the government, or in this case, private enterprise, have to collect this information? I think he would have been appalled.
It's complicated because, again, it implicates different rights of types of privacy. Here we're talking primarily, I think, about private actors for the most part. It's one thing if, because the question is, where is the government getting this stuff from? And usually it's getting it from, AT&T or a private bank or whatever. And most of the cases, as you know, as that technology has evolved, have allowed the government to do that with a warrant under the notion that if you give up this information to the bank or whatever, they can get it. Some states, incidentally, treat that differently under their state constitutions. Pennsylvania is one of them, dealing with bank records. But for the most part, that's the case. I think what Brandeis would look at is, how do you deal with this as a society? And I think it requires legislation if it's going to happen, frankly. I think most of this, you would have to get people sufficiently outraged at a certain point that you would have to say, enact the legislation to prohibit the dissemination of that material, except under certain circumstances. But it's not easy, because we're leaving trails of ourselves everywhere.
We also are raising a generation that is technologically sophisticated, that is getting I lost my cell phone a couple months ago, so I had to go buy a new one. My granddaughter programmed it because I couldn't figure out the instructions on what I had to do. I have a simple phone. It came with a camera because you can't buy a cell phone without a camera anymore. My granddaughters have iPhones, and they go, and they know how to access all sorts of things. And they're growing up in a society in which not only can they access everything, but they expect everything to be out there. The older notion of privacy is also being undermined by people like Paris Hilton, who thinks that every single thing she does, including going to the bathroom, ought to be up on YouTube or Facebook or something like that. And, this is creating problems for people who still have some notion that what I do is private and is nobody else's business.
I agree completely. In fact, last night we had to seize my 15-year-old daughter's cell phone because she came home late, and we had it for about 2 hours, and it was like we had driven a knife through her heart, that she was, out of contact with everyone. But there is, I think that the newer generations are so used to everything being out there, I'm not sure there is a sense of this right to be let alone that of the same sort that Brandeis worried about.
Although my granddaughter was impressed by the fact that Miley Cyrus no longer twitters. So this, that's the role models that they look at there. So
let's open this up for questions.
Yeah.
Yes, sir.
One moment.
Thank you. I was intrigued by the notion that you suggest that the founders couldn't have thought anything about wiretapping. I think they were very well aware that you didn't read somebody else's letters that were sealed. And I guess I have always been surprised at how freely everybody has always thought, there's a constitutional right to privacy, as opposed to it's a tort. It's a common law tort. It makes a lot of sense as a tort. Why is, there's so many other things that we would like as common law torts to be in the Constitution, but they're not there. why does this one have a special status? And I think as it evolves, I think you're right. It's we take a look at what we want to keep private. I think that most of the kids today, including your granddaughters and maybe Paris Hilton, maybe not Paris Hilton, because Hollywood types thrive on publicity, and therefore their notion of what they want to keep private is very different than the rest of us. But I think most of the kids in high school today, no matter what their phones, are not ready to let people into their underwear drawer. I mean, they have some limit on their own sense of what they're letting the outside world into and not. But I guess what I'm interested in hearing is whether or not you think that somewhere along the line we made a special category for this right by calling it a right, not a tort, and that makes it different, and maybe that's what makes Brandeis so unique, that he started us down that road compared to a lot of other things that I think are appropriately torts and we shouldn't do, but we don't try and ground them in a Constitution, First, Fourth Amendment, or whatever.
First of all, a tort is a civil wrong. It's normally between two private parties. What we're talking about here is the government, and that's what makes it different. The right to privacy is the right to be let alone by the government. So if you invade my privacy, I sue you, but not under a constitutional right. I sue you as a tort. If the government invades my privacy, that's a Fourth Amendment violation. That's a constitutional right, and I think that's the difference between the two.
And I just guess in response to that, the thing that troubled me so much at the time, as I understood it, the case was when people were complaining about the FISA Act and the amount of information that the government wanted was that if anybody from a foreign country, they didn't have to be a terrorist, came here and opened any kind of business, they could subscribe for not a lot of money to a credit rating company and find out a ton of information about you. But when the government wanted to buy the same data, which was out there, and your neighbor or anybody else in the world could buy it, they were told, oh, no, that's private. And I thought that was so hypocritical that if you want to put it out there for private companies, aren't you making it available when the police can search just the way you would any other data for that reason?
You want to take that one?
Way in the back.
Hi, my name is Mark Rotenberg. I've been teaching privacy law for about 20 years. I haven't finished the book. I've made it part way through. I do want to say what I've read so far I enjoy very much. So for people who are here tonight, please purchase Professor Yarovsky's book.
I did not plant him. I did not plant him.
No, you didn't. The second point which I wanted to mention is that in teaching my class, I point to the ongoing importance of Brandeis's influence by reference to the Bartnicki versus Vauper case a few terms ago involving a First Amendment versus a wiretap claim. And what's significant in the case is that there's majority opinion, Stevens, concurrence, Breyer, dissent, Scalia, and they all quote Brandeis for different results, but it all seemed important in that particular case for them to reference Brandeis. I also want to say with respect to the Facebook generation, I actually have a very different view of what's going on. And in some respects, I think Brandeis would actually be quite proud of the way in which young people today, particularly on Facebook, are trying to exercise control over their digital identities in this online world. Because as you know, there's actually been a lot of controversy back and forth between the users of Facebook and the service itself, largely over who controls the disclosure of the information, the content, the wall posts, and so forth. You have 100,000 people, young people this year, who protested a change in the terms of service. And to me, you know, the great insight about the Brandeis Warren article, it wasn't so much about privacy in the home, it was about what happened once you left the home. Could you control your identity in a public space? And I actually think that young people have sort of intuitive sense about this. Okay, but there is a question.
Okay, I hope you're right on that.
Yeah, I follow this pretty closely, and I've really been struck by, even in the articulation, that people see themselves as controlling their identity, which of course was central to the 1890 article. But here's my question, and it's just kind of sort of a straight-up doctrinal question. So in 1928, in the Olmstead dissent, Brandeis says that the search is impermissible, warrant is required. And so we all teach the class and say, well, 40 years later, Brandeis was vindicated in the Katz opinion. We get the federal wiretap law. But, of course, we get all these decisions on the reasonable expectation of privacy that seem to go the wrong way. And people begin to say, well, the doctrine's kind of circular because, the reasonable expectation of privacy ends up being whatever court concludes it is. So the question I've actually struggled with for this 20-year period of time is, did Katz really vindicate Brandeis, or was he actually saying something else in Olmstead? For example, he likes to talk about the Fourth and Fifth Amendment running together, suggesting that there might have actually been an absolute prohibition on the search, yes, that might not have allowed the type of post-Katz results that we saw in many of the courts. And I don't know if anyone has thought about this particular issue, but it would seem to me to be important since, in some respects we kind of credit Brandeis for the Katz result, and at the same time we know that what followed after Katz was not always satisfying.
Well, certainly it is true that the law has continued to evolve in that area. I mean, I view Katz as a vindication for Brandeis because it did establish this as a search and seizure under the Fourth Amendment. And so if you look directly at the Olmstead case versus Katz, I think that, the majority would be the dissent in that case. And so I think it's a victory. Would he be personally upset, unsatisfied, and appalled by some decisions as the Fourth Amendment jurisprudence has progressed? Certainly that's the case, I think. So he would be the dissenter in a lot of modern cases. I think there's no question about that.
I think so. I think that if Brandeis had his way, there would have been no wiretapping with or without a warrant. But Katz, if I'm not mistaken, doesn't Katz specifically overrule Olmstead? It says so. I think it says so specifically. But does it go as far as Brandeis' dissent? I don't think so. And so the vindication is in the overturning of Olmstead more than perhaps in the full expression of what Brandeis was hoping to achieve.
And part of your point, I think, though, is broader than that. When you go to a reasonable expectation of privacy, you make it very fluid in a way that can erode it. And if a society is going in a direction that is abandoning its adherence to notions of personal privacy, it can lead into and I think this is part of your point, you can lead to some erosion of the standard in a way that Brandeis might not have wanted.
And if I could have just a brief follow-on, it was Smith versus Maryland, one of the more significant post-Katz cases where the court rejected the reasonable expectation of privacy test for the transactional record information, the toll record information, that in fact the Bush White House relied upon in part in the warrantless wiretapping program. Attorney General Gonzalez said the court is held. You have no reasonable expectation of privacy in your telephone toll records. And I think you're right, Professor Urofsky. It just can't be the result that Brandeis would have imagined.
Yeah. Part of the problem, I think, lies in the law itself. I went to law school at age 40, and so perhaps had a somewhat different take than some of my younger students there. And one of the things that I recall is that they all wanted bright-line tests, no matter what the course was. What is the law? What's the bright-line test? And they would get extremely frustrated when told, well, there really isn't a bright-line test. There are circumstances. A reasonable expectation may mean A or it may mean B. Brandeis certainly understood this. I suppose he would have hoped that judges would have been along what we would say on the same wavelength that he was when interpreting this, but he certainly understood that the law is not always rigid. The bright line test doesn't always work. So I think you're right in the sense that once we put tests like reasonable expectation in the hands of courts, It's like the old clear and present danger test. In a conservative court, everything was clearly and presently dangerous. And, it wasn't a very good test because it was so subjective. And I think reasonable expectation suffers from some of that same problem.
Questions? Other questions? Way in the back.
Hi, my name is Ed McNicholas. I had a question because I was taken by your comment about judges being asked about their technological abilities during the vetting process. And my question goes to institutional competence. Do you think that we should leave, the question is, do you think we should leave protection of privacy primarily to judges, or do you think that at this point the technology is moving so quickly that we should have an agency dedicated to protecting privacy, that we need to move it out of seeing this is something that we primarily protected by judges and move it towards something where we have a federal agency to do this? Because at this point, we're really the only advanced industrialized country that does not have a separate regulatory body dedicated to protecting privacy.
I think what's needed is a mixture of statutory, regulatory, and judicial framework here. I do know a friend of mine was the privacy commissioner, which is sort of a contradiction in terms, up in British Columbia, but that was his job to monitor invasions of privacy, and to interpret the law to protect privacy. The article that Jeff Rosen wrote was not so much that the judges had to be able, to program a computer themselves. What he was concerned about is that they understood the ramifications of technology. Let me give you a personal example on this. I'm from an older generation. I didn't get my first computer till I was well into my 40s, and I was shamed into doing it by one of my sons. Okay? He was my tech support for a long time, and his first question usually was, did you turn it on? But I always, when I ran into a problem, always assumed that the computer couldn't do whatever I was asking it to do. Philip's assumption was the computer can do it, I just have to find out how it's done. I think that's a generational difference in how we look at things, because he grew up on the assumption, if I ask the right questions, it will do it. And what Jeff was suggesting is that not so much that the judicial candidates be able to program, but that they understand the ramifications of technology, how they impact daily life, what they mean in terms of the law. And that's a much different question. I think, to some extent, what he believes is that the main items that are going to be on the judicial agenda for the next generation are going to be primarily technological. Whether he's correct, I don't know.
Stop 1 second. I come at this because I advise tech companies on privacy issues. And when offering that advice, I'm often looking forward at next generation technologies. And by the time the millions are invested in that technology, it's rolled out, and it does what it does with the personal information, the courts may look at that 3 or 4 years down the line. 3 or 4 years down the line, that technology may be worthless because it's now 2 generations back. Mm-hmm. And so the courts may systematically undervalue and be unable to address this issue because they're looking retrospectively at cases and controversies, and it takes a certain amount of time for those cases and controversies to be generated.
Yeah, that's a great point, and I guess that was one of the reasons I wanted to talk about these different offshoots of privacy and events in our society that have triggered them, because very honestly, I do think at this point, with everything happening so rapidly as you're accurately describing it, any real significant change, if it's going to happen, in my view, is going to be statutory, or an act of Congress or of the state legislatures and creating regulatory agencies. Whether we're going to have this privacy commission, I don't know. But the second point is you have to think outside the box. I mean, these other types of privacy didn't exist either, and then things happen. required us in many ways to invent them. And so I think that's a very creative idea, and I think whatever it is, something's going to have to give before too long with all of this explosion, and my sense would be that it would have to be statutory.
We have time for one more question.
Hi. I was wondering, with relation to the social networking issue, I understand that breaking things into different sections on the internet, like saying the government's able to check what you've searched for, I find that to be awful. But I find that when someone is on Facebook or YouTube or MySpace or on some sort of blog, and they post something to their website, they're actually making it public. For example, the Holocaust Museum shooter posted on his blog the night before that he was planning on going to shoot. He was planning to go on a crusade, I believe is how he put it. He made that public. How do you think Brandeis would have felt about, preventing the murder of that security guard with the information already known and made public by the shooter?
There's no problem there. He made it public.
Well,
there's no privacy issue if it had been one thing if he'd sent an email or he was writing a diary. This is not public. Emails do become, but they're not supposed to be. But I mean, he posted it.
Right.
And as far as I'm concerned, once you make something public, you've given up your right to privacy regarding that specific announcement. And I would think, and I imagine Brandeis would as well, though as a historian I'm always very leery of saying Brandeis would have done this or that. But I think anybody with common sense would have said once it's public, any right to privacy there, especially since he put it up, not somebody else.
Right.
All right to privacy is lost there.
So wouldn't that be tied into all the social networking then? I mean, if people are going to post it, that automatically becomes public, right?
Well, the question is, if you post something about yourself, that's one thing. If somebody else posts something about you that you may not wish to have posted, that's a different story.
I understand.
You've sent the picture to your friend.
Right, I see.
And all of a sudden you see that picture. There were analogs to that 100 years ago in just a physical picture, but now the potency of that kind of distribution is so great, and just a little back and forth that we just did on is an email public or not leads to part of the problem. I mean, is it? I mean, have you created essentially a public record for one purpose or another? Let's continue this conversation informally, but first let's thank our panelists for a really wonderful conversation.
Thanks a lot.